I appreciate the opportunity to be here with the Republican women in Ponderay County again. It's always a pleasure. I see some familiar faces, and let me ask you a question right off the bat. For a kid that grew up in Rathdrum and graduated from Spirit Lake Elementary, how many of you are property owners? Own land, a house, a cabin, whatever. Okay, pretty much everybody. And Fifth Amendment, we all know what the Fifth Amendment is, right? Protection of our property. And it was very important to the Founding Fathers: life, liberty, and the pursuit of happiness. And the pursuit of happiness was all about land ownership, right? It was life, liberty, and property. So if you have occasion to have someone challenge your land ownership, they assert some kind of dominion over it. They think they own it or own a part of it, or they think they have an easement or a right-of-way across it, and they file an action in court. What are you going to do? You're going to defend your property, and you're going to expect the government, in this case the court system, to uphold, recognize your property rights. If you don't do that, if somebody files a quiet title action and you don't show up, what's going to happen?
They'll own a piece of it.
You bet. You're going to lose by default. Happens every day in this country. So if somebody, let's say it's the government, comes in and claims ownership over your property, there's no doubt that you're going to fight that tooth and nail. Now, how many of you own a water right? How many of you think you might own a water right, but you're not sure? How many of you have a piece of paper, a permit, a license, or a decree that has a water right number on it? Okay. How many of you have a well that you use in your own home? Okay. You all that have raised your hands in the last two questions definitely have a water right. If you have a permit or a license or a decree with a number on it, that's a water right number. If you have a well that you use in your own home or small business, you have a water right. It's unrecorded, probably doesn't have a number with it. Maybe it's got a drilling permit, but that's not the same as a water right. That's good evidence of your water right. Why do I ask that? Well, in Idaho, as in most states, a water right is private property. Look at Idaho Code Section 55101. 55101. Real property includes land, water rights, etc. So if someone filed a lawsuit and said, if you think you have a water right, you've got to file your claim in this process or you're going to lose it, and someone else may file a claim for that water, and if you're not there, you're going to lose it. It's the same as the quiet title action. That's what an adjudication is. So probably next year, the legislature will provide the funding to start the adjudication in the Clark Fork Ponderay Basin. The adjudication is already going on in the Coeur d'Alene Spokane River Basin. It's getting close to being done. And we could debate whether it's a good thing to have an adjudication or not. But let me ask you this. If you had to fight to protect your claim, and when I say yours as an individual, a family, a business, or just the larger community, the area, the water rights that are needed in this area for the future, for economics and everything else, would you rather fight over that with the federal government or the government in general in a federal court or in a state court?
My choice should be a state court.
State court. So in the 1950s, Congress recognized that there were these water right disputes going on all over the country in the West, and that the neighbors would fight it out, but the court would issue a decree in that local area, and there was a major landowner, so to speak, a major interest not involved in that adjudication. Who was that? The federal government. You cannot sue the king without the king's permission, right? 11th Amendment. It's farther down the list, but it's still an amendment. So, in the 1950s, Congress, recognizing this problem, waived the sovereign immunity of the United States for purposes of being sued in a state court to resolve water rights disputes. So that means that the state of Idaho, or any other state, can commence an adjudication by filing it in a state court and serving the complaint on the federal government, just like anyone else, and requiring them to come into the case. So that is what the adjudication is that's going on in Idaho. It is concurrent jurisdiction, meaning it doesn't eliminate the ability of the federal court, if they think they have a water right, to file it in federal court. So if there is no state adjudication going on, they can file in federal court. If there is a state adjudication going on, federal court's not going to waste its time with what's the state law issue dealing with water rights. So that, in a thumbnail sketch, is the argument of why the adjudication is going on. When the adjudication starts up here, there will be a claims-taking process. So all of you that raise your hand that you have a water right, you will need to file your claim in the adjudication. If you don't, you'll end up doing it later, because if you don't file it, you'll lose it. That's what the statute says. They want everybody in the barn. So even if you have a vested decreed water right, if you don't claim it in this process, you can lose it. Now, if you have a domestic well, just a second, if you have a domestic well, you are not required to file a claim. It's what's called deferrable. You can defer it forever. There are people in southern Idaho, the adjudication started in 1987, and they just decided, I think I'm going to go ahead and file a claim on my well 30 plus years later. They can do that. Their kids and their kids' kids can do it. It's deferrable forever, as long as there's a court to file the claim in. Everybody else that has irrigation or the federal government, an industrial claim, you have to file. That you have to file requirement applies with equal vigor to the United States of America. If the United States does not file its claims, whether they think they have a water right for the Forest Service or for an Indian tribe or whatever it is, if they don't file those claims, they will lose their ability to claim that forever. And when the final decree comes down, the shadow that's hanging over us of the federal government thinking they've got authority is limited to whatever they got out of that adjudication. They can't come back later and claim more. There's finality in the process. Yeah.
Does that also apply to a surface well?
A surface well, so a spring?
Deep, hand dug, say, or something like that?
Yes. Any water source that you use for beneficial purposes, you're going to want to file a claim for. Okay? There are some exemptions, but for the most part, if you've got a beneficial use of water, you want to file a claim. Now, why do you want that? So we're back to court. Somebody sues and says, I own that land because I've been monkeying around there for 50 years and it's mine and da-da-da. What's the first piece of evidence you're going to slap down in the courtroom? Here's my deed. I was conveyed this property. I bought it for good money. I own this. The United States comes in and says, well, we think that we own this water source that's flowing through there. We think we have a water right for that. We had a grazing permit that we issued to someone, and we think we have the water right, or we own the forest reserve above this, or whatever, manage the forest service reserve above this, or whatever. What's your response going to be? Where's your piece of paper? So if you file a claim in adjudication, you're going to end up at the end of that process with a piece of paper, a decree issued by a court. So you've got your land and you've got your water right. They go together, and you've got pieces of paper indicating each of them. Well, wait a minute, Norm. On my deed, it says that it comes with the water rights. Well, that begs the question, what are the water rights? This will define whose water right it is, for what purpose, in what quantity, diverted from where, from what source, so that when there becomes a time where that's questioned, you've got a definite decree that says that. Yeah.
Several decades ago, I went to real estate school back on the East Coast.
I'm sorry.
I know.
So we're not on the East Coast, first of all.
Is this a new thing?
So anybody familiar with the patent to your land? When land was patented to you? What language is in there, Linda? It reserved to the United States, this and that and the other thing, right? So even clear back at the time of patent, when the United States patented the land to somebody under the Homestead Act or whatever it was, the Carry Act, it reserved to the United States certain things. And the water was severed from the land. That's U.S. Supreme Court precedent. So I don't know what you learned, where you learned it, but you own your land, but it's subject to, if somebody's got an easement across your land, if you've got mineral rights reserved by the United States, whatever it is. Now, hopefully you don't have that, and it's going to be fact specific. But don't get me wrong, if you have a water right, it's pertinent to your property. It's part of your property. If Carrywood Creek flows through your property, though, you don't own Carrywood Creek. It's a navigable water. When the United States granted statehood to the state of Idaho, the state of Idaho acquired the beds and banks of all the navigable waters in the state. So the beds and banks of Carrywood Creek or Lake Ponderay or whatever are owned by the state of Idaho. You have a right to use that water if you've developed a water right, but you don't own the stream. The state owns that. Does that make sense? Okay. Yeah.
Is there a standard to establish a navigable waterway? Does it have to float a 16-foot boat or something like that?
Yeah.
So what is a navigable water? So there's a couple of different times
You
when...
can float a little toy boat in it. Do they call that navigable? Or?
Yeah, there's different tests of navigability, right? So the test of navigability at the time of statehood is different than the test of navigability for regulation under the Clean Water Act. They're different things. Under state law, there is a test of navigability for when someone can publicly access and use a waterway, and that is you can float a 6-inch diameter log, I don't know how long, but a 6-inch diameter log, or a boat. It could be a canoe, whatever. If you can float that, either one of those in the water, then it passes the test of navigability under state law for purposes of the public being able to use it. Because these questions have come up in southern Idaho, the Peekaboo livestock case, where the fellow owned that land, that stream went through there, he said, I own all the land, including what's under the water, and the question became, is it navigable or not? Because if it's navigable, people can float on the water. They can't get out and travel on your private property, but they can float on the water, or is it not? And in that case, the court found that it survived the state test of navigability because people could float through there. And so he had to take his barbed wire fence out of the middle of the stream. So that test of navigability is much different than what is the waters of the United States, which is the definition for navigable waters in the Clean Water Act. Because in that case, we know that some things that we would call dry dirt have been considered to be navigable waters of the United States. So it's a different test for different purposes. It depends on what you're looking at. Title at time of statehood, of submerged water, of submerged lands, or if you're looking at regulation. But back to the adjudication. So you file your claim because you want to protect your property right. That's number one. Number two is, remember in my scenario on the land ownership, someone else is claiming ownership over your land or some interest in your property that you want to prevent from happening. When the adjudication starts, you should focus on your claim and make sure your claim is filed, because you want to have that decreed, number one. And number two, it makes you a party to the adjudication. Nobody is a party to the adjudication except for those people that file claims. So your neighbor who's not a water right claimant is not a party to the adjudication. If you live in a subdivision and the subdivision owns the water right, the subdivision, HOA, files a water right claim. You as an individual are a member of that HOA, but you as an individual are not a party. The HOA is. Does that make sense? Or a corporation, or whatever. Whoever owns and files a claim for the water right is in the game. to get their own water rate decreed, and then, along the way, the federal government will show up. And it's very important to know that in the Snake River Basin adjudication in southern Idaho, there was an argument that this McCarran Amendment, this is the act that Congress passed that waived sovereign immunity that said the feds have to come in. The state took the position and prevailed in the Idaho Supreme Court saying the federal government has to pay filing fees just like everybody else. Congress waived sovereign immunity, got to be in. The U.S. Supreme Court accepted that on appeal because it was a federal law question about what that McCarran Amendment meant, and they said no, the waiver of sovereign immunity doesn't go that far. It doesn't extend to fees. So in other words, they're required to participate, but they don't have to pay anything for the claims that they file, which means they're going to file a lot of claims. They're going to file whatever they can imagine, right? So, for example, in the Coeur d'Alene Spokane River Basin adjudication, the Forest Service, the United States through the Forest Service has filed somewhere in the neighborhood of 260 claims for all the water sources in all the forests in that area. So when we get up here, probably they're going to file something similar. All the water sources on all the forests, are you below the forest? Are you in the forest? Are you going to be impacted by those claims? They're claiming all the water. How much are they claiming? For what purposes? Are you concerned about that? You won't know until you see those claims. That's number one. Number two is 353 claims were filed by the United States through the Bureau of Indian Affairs for the Coeur d'Alene tribe. 353 claims. Those are sitting in front of the Idaho Supreme Court right now, deciding how many of those 353 claims may have any validity to them at all. What's going to happen up here? We don't know. Coeur d'Alene Reservation's not here, but we all know that there are historical interests and there are federal presence, and the federal government, have a trust responsibility to tribes. Who knows what's going to be filed? If you have a concern with what the Forest Service files or what the Bureau of Indian Affairs files, you can object. You can file an objection. And if you and 100 of your friends, or in the case of the North Idaho Water Rights Alliance out of St. Mary's, 400 of your friends, or the Northwest Property Owners Alliance in the Coeur d'Alene area, another 400 of your friends, or the Coeur d'Alene Lakeshore Property Owners Association, another 100 of your friends, all file objections together and pass the hat to fight the army that is the Department of Justice, because they're going to defend all these claims, then you have a chance to beat this back, to try to respond to the court action where they're trying to claim all of your water. Because what good is your water right? Let's say you're on a spring or an interconnected groundwater source. If they need all the water with the best priority in the basin, during times of shortage, the guy with the most senior right gets all of his water before the junior gets anything. So it's a major concern. You can only file an objection if what? You are a party to the adjudication. You're only a party to the adjudication if you filed a claim. If you don't file a claim, you can support the folks that are in the game, but you aren't in the game yourself. So filing a claim is important, number one, to protect your water right, your actual water use, and number two, to be able to band together with others as it may be necessary when those federal claims get recommended, or when they get reported to the court, because if they're not objected to, they will be decreed. Just like in the other scenario where if you don't show up and fight it, it will be decreed. Now the good news here, if there is any, is that the state of Idaho is pretty good about filing objections to these claims. And a lot of times they do a good job, but it's a lot easier, from my experience, both in the Snake River Basin adjudication and the Coeur d'Alene Spokane River Basin adjudication, it's a lot easier to see them doing a good job when there's somebody in there with them, and when they see that they're maybe not quite doing it the way it should be done, you get to tap them on the shoulder and say, we think you ought to do it this way, and if you don't, we're probably going to file a motion, or we're going to file a response, or we're going to file an objection. All of a sudden, you're a player in the game. If you're not there, you're reduced to, how many of you are familiar with the water rights adjudication in Montana? So the compact. So here's what happened there. Tribal claims are out there, filed by the United States. State of Montana says, all right, we're going to form a compact commission. The state of Montana, so in our case, that'd be like the Attorney General's office, the federal government, Bureau of Indian Affairs, Department of Justice, and the tribe will go in a room and they will work this out. And they will announce what the water rights are. Can you imagine? You're not in the room. Your claims don't matter. You don't get to file an objection. That's not how our process is set up. But if we don't object, that's how it was going to happen in the Coeur d'Alene Spokane River Basin adjudication. They were already preparing for a negotiation between the Attorney General's office, the tribe, and the United States. But then what happened? The legislators picked up on this. They passed a resolution that wasn't exactly what was originally proposed, and said everybody that's involved in the adjudication, everyone that's a claimant, they didn't even say you have to file an objection. Everybody that's a claimant gets to be involved in whatever negotiations happen. And then when that was passed, there were objectors, hundreds of people who filed objections, so they automatically had a place at the table in the negotiation. No settlement could be signed without them all signing off on it, and nothing could happen in court without those individuals being there. So if you aren't involved, if you aren't organized, and there is no better group to help do it than Republican women. And I can tell you that as a former chairman of the Idaho Republican Party, but I can also tell you from the experience of what has occurred south of here in the Coeur d'Alene Spokane River Basin adjudication. Strong Republican women leading the charge, getting people organized, sit down, shut up, listen, this is what we need to do, you need to listen to this person, blah, 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 we need to do this is the deadline, this is where you need to put the money, give me $10, you know how it goes. So, yes.
When you were describing how the federal government and the tribes were making claims, let's say there was a ranch there that had been there 100 years and the third or fourth generation is on it. They've been irrigating and doing all their ranch stuff. Does the doctrine of prior appropriation amount to a hill of beans anymore?
Great question. So let's imagine, give me a date. When did this ranch start?
Before the claims by the tribe.
Give me a date. Give me a date. 1880?
1890, something like that.
All right, 1890. So date of statehood, 1890, right? What is the priority being claimed by the United States on behalf of the tribe for in-stream flow? So let's imagine your ranch is somewhere along the stream. You divert from this particular stream. The United States comes in and claims an in-stream flow for fisheries, and they need all the water there all the time. Certainly during a dry year, they got to have more water than what's there. Their priority is what? Time immemorial. They've been here forever and ever and ever. That is the priority date recognized by our adjudication court in the Coeur d'Alene Spokane River Basin adjudication that we have taken up on appeal to the Idaho Supreme Court, and we're awaiting a decision on. So to answer your question, they would agree with you. They would say, yes, first in time is first in right, and we were first. And we get all the water before you get anything. So your open mouth is telling me that you understand why it's important for us to file objections. Because if you don't file an objection, they will get exactly what they claimed or what the state is willing in a vacuum to agree to without the context of real folks with real interests. I'm not saying they're bad people, but if you don't have the folks in the negotiation room, the negotiation is probably going to come out different if it's just three governmental entities negotiating with themselves about what the tribe should have. Well, I'm not going to say that they are, but our experience is that when we file objections, and this experience goes back 25 years, when we file objections, we the water users, we the people, and the state is a co-equal party with us, they don't get to just say, well, we'll keep that in mind as we go over here in this locked room and talk. Instead, we're all in the room together. And keep in mind that the first negotiation session that we tried to have A couple of years ago in Post Falls, there were over 300 people there at Templin's and a couple, 7 security guards. We're all in the room, and we can't be excluded. But if you don't file the objection, if you don't get organized, if you don't file your water right claim to be eligible to file an objection, you will be out of the room. It literally only takes one person filing an objection to have standing to be in the room. But how much easier it is when the form objection is prepared saying, we object to all these tribal claims or all these Forest Service claims, and then behind that is a list of 100 or 300 or 400 or however many people that are water right claimants, and slapped on top of that is the name of your group. Whatever you want to call your group. North Idaho Water Rights Alliance is one of them down south. Can't believe I'm calling Coeur d'Alene down south. That's the way it operates. It's too early to do it now. The adjudication hasn't commenced yet, but when you start hearing rumors and rumblings about they're going to be taking claims, and you'll see a date in there where they say, you have to turn in your claims by a certain date, and then there'll be a second round, and then they'll send out a recommendation, the Department of Water Resources. During that time period is when the federal claims get done. Before your stuff even gets done, those will be issued by the department. What they do is they take all the federal claims as they're received, and they just regurgitate them to the court. For your claims, the department will actually evaluate them and decide whether they're valid or not, which doesn't sound good, but it's important because once they review it and say, yeah, we think you're right, and they send that to the court, you don't have to do anything else. As long as nobody objects to your water right, because the department's reviewed it, it's presumed to be right. It's prima facie evidence, and you'll get a decree. The federal claims just get put in a box and dropped off at the court. There's no presumption that they're right. They have to prove every element of the right. But if nobody objects, that's a lot easier for them to do. I'm not familiar with any federal claim that hasn't been objected to. That's the good news. The bad news is sometimes it is just the state that catches wind of what's going on. And these things aren't widely advertised. You kind of got to know what's going on. So you'll get a notice that, hey, the department's got a record, there's a water right with a number that has your name in it on it, so you may want to look at filing a claim. They'll send you that notice, but they're not going to send you a notice of, hey, there's a federal claim on this stream that you rely on. You might want to look at this. They don't send you that notice. You've got to figure it out yourself. So that's why it's important to be informed, to be educated, to understand the process, and to be very diligent and very vigilant. Your legislators have helped you out as much as they can. I see you've got at least one in the back of the room here with Sage. But they can only provide you with the tools and try to make the playing field as fair as possible. You are the one who actually has to be the player and show up. It helps when sometimes the legislators are parties. We've got a few of those in the Coeur d'Alene and Spokane Basin Adjudication who are actually members of the North Idaho Water Rights Alliance and water right claimants. So, yes.
When I've looked into this before, like you had mentioned, you have to say how much water you actually use from that source. How does one go about figuring that out? And then do we have to get a lawyer when we go to adjudicate our own well?
No, you don't have to have a lawyer. If it's really complicated though, don't get a lawyer and then let it get all messed up and then come see me later because it'll be more expensive. No, if it's a well, it's for one home or maybe two. It's a de minimis use. So what the state does is it provides for up to 13,000 gallons per day. That's way more than you need. 13,000 gallons a day is enough for a home and irrigating a half an acre. They say up to 13,000 gallons a day. They don't calculate, well, you really used 5,842 gallons last year. Your water rate would just say up to 13,000 gallons. So you're just going to have to pay the minimal filing fee. You get the up to 13,000 gallons a day, and that's how it'll be decreed. Now, we'll tell you that down south, way down south, in St. Mary's, at that negotiation meeting that we had in Post Falls, the tribe's attorney at the time used the occasion to announce that my words, not his. Because you've objected to our claims, we're going to object to some of yours. So they filed 50-some objections, the tribe. Now keep in mind, this is just a matter of fact, the United States is the trustee for the tribe. So the United States files the claims through the Bureau of Indian Affairs for the benefit of the tribe. The tribe doesn't do that themselves. The United States does that. The United States did not do this. The tribe showed up in the adjudication, Coeur d'Alene tribe, just for the purpose of filing objections to individual water right claims. These 13,000 gallons a day or less claims, saying, well, we see that you filed this claim for 13,000 gallons a day, but your claim says you have 5 goats. And we don't think 5 goats drink 13,000 gallons a day, so we want the department to figure out exactly how much you really use and put that in your decree and limit you. They did that to 50 of the folks that were brave enough to be in our group. They didn't get much out of the process. Another argument was, well, you have a water right from the St. Joe or Lake Coeur d'Alene on the reservation, and therefore we, the tribe, own the submerged lands, and you didn't get a permit from us to divert that water, so you don't have a water right. That was another objection they filed. They lost miserably on that one. Because the land ownership, the submerged land ownership, has nothing to do with the water right, and the court told them that. But the point is, they can do that. Now, the federal government did not do that. So I don't expect, as the adjudication moves up here, that the federal government is going to object to people's water rights. They don't do that. They're trying to collect water rights in the name of the United States, whether it's stock water on federal land, which they lost on big time. Does anybody remember the Joyce decision or heard of the Joyce decision? The Joyce decision was a decision by the Idaho Supreme Court about 12 years ago that decided the ownership of stock water rights that are used on federal land, diverted on federal land, used on federal land under a grazing permit. Who owns that water right?
The person with the grazing lease.
The person that actually puts the water to beneficial use with the cows, the grazer, the permittee, not the federal government. That was a big loss to the federal government. What happened before that decision was issued? Tens of thousands, and I mean tens of thousands, of water right claims filed by the federal government were put in the box and dropped off at the court, and nobody objected. So guess where all those are now? They all have decrees. Tens of thousands of federal decrees. And then the Joyce decision came later. Can you undo all those decrees? No. So there are all kinds of discussions about how to fix this and undo this, but it is a very stern demonstration of if you don't show up, you will lose. That's the way the process is set up. If you don't show up, you lose by default. So those were all default decrees, but they exist. Yeah.
Is the federal government required to notify the property owner that they're going to do this?
Is the federal government required to notify the property owner they're going to do this? So, for example, if they require all of the water to be downstream somewhere, and that could require turning off the upstream person, no. They are not required to notify you of anything. Interestingly, anything you file in the adjudication has to go to the Department of Water Resources, the Attorney General's office, and the Department of Justice. It's required. But anything they file, they don't have to send it to anybody that they think might be impacted. That's not part of the equation.
So all those things that they decreed back then for this, whatever you talked about, nobody was notified that they were going to take their water rights away.
Nobody was notified. So that's a great question. So if the federal government files for water rights for stock, they didn't have to and didn't notify the grazing permittee. Now the grazing permittee can, it's one of these deferrable claims. They can file but didn't have to file. And what are most cowboys going to say if I don't have to do something, why am I going to do it? Especially if it costs money. So all these default decrees just happened. Now there were some folks who thought it was important enough to file claims, that they filed their own claims for that water, like Joyce. That's how the Joyce decision got decided. It was what should have happened through the whole adjudication. Federal claim against private claim, court decides it. You can't do that when there's federal claim and no objector. It just gets decreed by default. So one of the prominent folks that was involved in that, before he was Speaker of the House, before he was a president of the Idaho Cattle Association, was Scott Bedke from Oakley, Idaho. He was a client of mine. And he fought tooth and nail in the late 90s, early 2000s, objected to the Forest Service claims in his allotment, and filed his own claims. And he didn't go all the way to the mat like Joyce did. He didn't need to, because frankly there was a friendly administration in place in the early 2000s, and we were able to get a settlement that said Bedke gets a water right, and all of his friends that are in this group, and there was a big group of permittees all across the state by then that were fighting the federal government, you all get a water right in your name. We're not going to undo the federal one. It doesn't mean anything, but it's still there. Part of what you've seen, if you follow the legislature the last couple of years, is trying to undo that federal part and keep the private claims water rights in place. It can be done. It's just not easy. Yeah.
Norm, if someone is interested in purchasing a property that has water on it, like a creek, a small creek, would they contact IDWR to find out if there's a water right? Or how would they go about it?
How do you find out there's a water right on your property or property you're interested in buying? You can contact IDWR. You can also, the Department of Water Resources has a website that has a pretty neat tool on it where you can search by legal description and it will pull up water rights. Or if you know the current owner, you can look it up by ownership. You can look it up by quarter. You can look it up on a map and see if there's a water right there.
Yes. And if a property owner wants to file for it, do you have any idea what kind of cost for this property owner to go through this process?
Yeah, there's a filing schedule. It's like $1 per acre for irrigation plus the $50 filing fee. I think the de minimis claim is either $25 or $50 depending on when you file it. It's not super expensive compared to what you're preserving, right? Some of the huge power rights and stuff, they're going to be pretty expensive, but you're not going to have to worry about the filing fee that a Vista puts in on Cabinet Gorge or whatever it is, right? So.
Can they apply for their water rights before adjudication comes through?
Okay, so we're talking about two different things now. So if you have a water right that existed before the adjudication started, it's been there for a long time, your well's been there since 1977 or 1997 or whatever it is, you're going to file a claim in the adjudication saying, I want you, court, to recognize the right that I've already established. It's already out here. It may be an old licensed or decreed right. It may be just a beneficial use right that you didn't have to get a permit for, but you've nonetheless developed it. Versus, I just moved onto a property and I want to have a new right to divert out of this creek to do some irrigation. That doesn't go in the adjudication. That you file an application for permit, not a claim, an application for permit with the Department of Water Resources. Whole different process. Federal government's not going to be involved. Different deal. Doesn't go in the adjudication. Yeah.
If a person lives out of the state and is the legal owner of the property on all paperwork, and a family member lives on the property, and there is a trust deed for that person that lives on the property to be the owner of it in the event that the legal owner of the property should die, then what happens?
In terms of notice?
Who's gonna be notified? The person lives out of the state, the person that lives on the property that's in a trust deed.
Not to dodge your question, but who's going to be notified is the owner of the water right on the records of the Department of Water Resources. So when you pull up that water right for that property, whoever's listed as the owner is who is going to get notice. Now, there's a duty by the owner, new or old, to notify the department anytime there's a change in ownership. And there's a form on the department's website, or you can get it in their office, for a change of ownership, where you attach a copy of the deed, the conveyance showing that you're now the owner, and they will transfer the ownership of the water right on the records of the department over to whoever the true owner is. Great example of this, 9 Mile Cemetery District in Wallace that provides the water for all the cemeteries in the area. The owner of record, his name I'm forgetting, but he is the one who filed the proof of ownership to get the license for the water right in 1912. He's not around anymore, but that's who the notice was sent to back in the days when Wallace apparently didn't have a zip code. So the record literally says this guy's name, Wallace, post office 000, zip code 0000.
Oh my goodness.
What do you think the chances are that 9 Mile Cemetery, who now owns it, but didn't submit any kind of change ownership, didn't know they needed to do that in 1967 when they became the owner, what do you think the chances are that they filed a claim? Well, 0, because they didn't even get notice that the adjudication was going on. They heard some whisperings and rumblings and rumors about it, so they whipped up a claim and filed it, but it had no basis, so it got denied. So by the time they get to me, your question earlier, we got to file a motion to set aside a partial decree that's been issued disallowing this licensed water right that's existed since 1912 and allow the filing of a late claim because the record wasn't correct. And it's not hard, we haven't had the hearing yet, but I don't think it'll be hard to convince Judge Wildman that there was an effective notice to the owner of the water right because the person they sent it to hasn't been around for a while. I think there's still some relatives, but they didn't get it.
Assuming everything goes south from the landowner's or personal property owner's position, 10 or 15 years, what ramifications could you see? What would these water rights owners, be the tribes or the federal government, do to the property owners?
What happens to the property owners if everything goes to heck? So have you ever heard of the Klamath Basin? What do you know about the Klamath Basin? People got dried up. These are war heroes who were granted tracts of land and water rights, but are junior to tribal claims that have been recommended by the Oregon government in the adjudication, which is the way their process works, is a little different. First in time is first in right. So, at some point, if the federal government has a senior right that is short, they're going to ask for it to be delivered. If they have a constituent that really cares about that, whoever follows Forest Service stuff, tribal government, they're going to advocate that the United States exercise their right and shut people off. 180,000 acres out of 200,000 acres in the Klamath Basin received no water in 2001, not because there wasn't water to divert, but because of a senior priority for the tribes that had to be, and fish that had to be recognized. So the consequences are dire. We lived in North Idaho. There's a lot of water in North Idaho. What are we worried about? Those in-stream flow claims would have been triggered in the Coeur d'Alene Basin in 2015 and 16, and I don't know about other years, but the claims are high enough that there isn't sufficient water to meet those minimum stream flows. The minimum stream flows have to be met in full before one drop goes to the next junior priority. If it's not full, no water goes to junior priorities. None. To make it worse, down the road, water rights administration will be done through water districts. Water districts are their own local government, like a highway district, and their job is to make sure that water rights get delivered by priority. And there's a guy or gal called a water master, and their job is to do nothing but look at the decree and say, all right, there's only enough water today for the U.S., so I got to shut everybody else off. The U.S. doesn't even have to ask for that. It just happens because that's the way the water rights are administered in a water district. So how the adjudication comes out, how the water rights are defined, who has water with what priorities for what purposes, will dictate how administration occurs in the future. Because all they can administer by is the decrees that are in front of them. So we have to get the decrees right. If we don't think the federal government has a right, we have to fight it. If we want their right to be not superior to ours. Now, there have been cases, and the Forest Service has been pretty good about this. For example, the wild and scenic water right on the Salmon River. I think it's a 1964 priority. Could have hurt a lot of folks that came after that and future development as well. They won in the Idaho Supreme Court on that, on the wild and scenic river, that there's a federal reserve water right for that. But they settled with the state and the local folks to say, we will subordinate, we will voluntarily make our right inferior to all the uses that came after us and some future development as well. They did that on the St. Joe River with the wild and scenic river claim. In this adjudication, the North Idaho adjudication, they agreed to subordinate. So they've got a decree, and it says in that case 1968, I think, for the St. Joe, but it also has a condition that says we're subordinated to all these other future uses, so they won't be shut off. That was only because of a negotiation with all of us that were in the room with the state of Idaho and the Forest Service and all of those people that I just mentioned at the Idaho Transportation Department in Coeur d'Alene. So negotiation can lead to a good result, because you're not going to fight every one of these things to the Idaho Supreme Court. Some of it you're just going to have to settle because it's too expensive, but as long as you protect your water rights, then the settlement is okay.
Who set up these water districts? I wonder what authority. It sounds like we're just giving away our local government.
So there's this thing called the Idaho Constitution. And the Idaho Constitution says, as to water rights, first in time is first in right. That has to be implemented. So the method that's been chosen to do that is, rather than someone from Boise being sent to each of the areas, and this was something the Department of Water Resources didn't really like. They liked having a state engineer with 3 divisions across the state, and they would administer the water rights. Statute was passed that there would be local water districts. And the local water districts are, let's say all of you are on one tributary. You have a water district, it's all yours. You meet once a year in an annual meeting, and you select your water master, and it may be her. You vote for her. She's your water master, not somebody from Boise. Now the department tries to convince you to hire them to be your water master. Honestly, this goes on. Hire the Department of Water Resources will be your water master. No, you can vote for one of the water users. That's who is, they're going to answer to you. They're going to be pretty sensitive to how they administer the water, but that's how it was set up. It's set up through state statute to implement water rights administration that's required under the Constitution. And if it's not done by a water master in a water district, it's going to be done by somebody, because it's the law. It's the Idaho Constitution. So what the federal claims allow the federal government to try to do is to wedge a senior advanced priority for a big chunk of water in front of all of our priorities. That's what we're fighting. All right, who has an answer? Danielle.
Is Idaho on track to become the first state in the nation to be fully adjudicated?
Are we going to be the first state to be fully adjudicated? If we're not, we're going to be the furthest along for sure. When the Clark Fork Ponderay Basin is done, all of the Snake River Basin, the Palouse, the North Idaho basins will all be done. So all that would be left, not that it has to be done, but the Bear River, which is not in the Columbia Basin at all, right? That river starts in Utah and winds around through Idaho and Wyoming and ends up back in Utah 90 miles from where it started. They've got a decree that's been in force for a long time. They have a compact commission that involves all 3 of those states. Folks down there feel pretty strongly like they don't want an adjudication, which is what they call it, adjudication. I don't know if they'll have one or not, but that Bear River Basin, and then Basin 98 up here, like way up north, right? Kootenai River. Okay. And I think it was excluded, I don't know for sure, but because it's a boundary river, it changes, goes to AY when it crosses the border or whatever, I don't know. Maybe that'll be revisited, I have no idea, but that would be the only part of the Columbia Snake River system in Idaho that's not adjudicated, would be Basin 98, Bonners Ferry, and places north. Have you ever been in Bonners Ferry and you're driving around and your phone says, "Welcome to Canada"? It's
I live on the Moye River, and I thought I was an hour late.
Yeah,
'cause-
Moy River, that's one of them that's not
Yeah.
adjudicated.
It's international waters, right?
No, the Moye
Yeah.
River dumps
No.
the Kootenai with the Columbia, so you say the boundary counts out of Moye Springs, that, those two rivers are not gonna be.
The Kootenai River is not part of the North Idaho adjudication or any of its tributaries.
Does it need to be, or because it comes to one?
Maybe the department folks will come up to Bonners Ferry and talk with them sometime about it, but at this point, it's not included, okay?
Thank you so much for allowing us to sort of have an open forum here, but I want to make sure that you get an opportunity to, because I know you said you wanted to talk about Avista and Hydro One.
Yeah.
So I'm going to be the police officer
Okay.
here.
So-
I want you to be able to,
Any other burning questions about adjudication?
Is the state of Washington weighing in at all on our water? It certainly does as far as water quality.
Yeah, state of Washington just finished an adjudication that started in the 1970s for the Yakima River. They just finished it like 2 Thursdays ago. So I know there's talk about potentially doing the Spokane River, which was part of the argument for doing the North Idaho adjudication for the Coeur d'Alene Spokane River Basin, was let's get our water rates all defined, because under the federal law, it's equitable distribution between 2 states. So 2 prior appropriation states like Idaho and Washington would probably go by who has prior rights. So Idaho wanted to get its house in order and get everything buttoned down. Washington may do the same thing, I don't know. But I've not heard anything definite about them doing an adjudication in the Spokane River. Yeah.
Is your North Idaho group, do they, have a website that kind of keeps people informed as to what data?
Yeah, check out like Norm, WPOA, nwpoa.org, Northwest Property Owners Alliance. They do a good job of keeping folks involved. They got the word out on their land use issues, and tax issues, and water rates issues, and the Avista issue. So I'm gonna yeah, go ahead.
And then the other question is, I'm feeling like I want to bring my paperwork into you to make sure everything's okay. Would that be an appropriate response from somebody who doesn't know a lot about this?
It's okay, but it's not the most effective thing. If you go onto the Idaho Department of Water Resources website now, you can find the claim form that is the claim form that they will use when they start the adjudication up here. It's not hard to fill out. If you are confused or want help, you already pay taxes to the state of Idaho. Call up the Department of Water Resources. There's a 1-800 number. A nice guy named Carter Fritchley in Boise answers it. He's the adjudication hotline. But they also have folks in their Coeur d'Alene office who by now are getting fairly experienced at helping people fill out claims. So the department can help you. I really don't think you want to resort to having an attorney until you get into these complex things where you're filing objections or the department's not doing what you asked them to do and you need to figure out what your rights are. Just simply filing a claim, they should be able to help you with that. But there are a lot of folks that would take your money to help you, I'm sure. But I think the department is the place to start.
I've referred clients to the Coeur d'Alene IDWR, and they've been very helpful to get their paperwork done.
They were good. They've been on a learning curve, and they've lost some people. One guy went to ecology in Spokane, Department of Ecology, but they do a nice job being helpful. And like I said, you can call the 1-800 adjudication hotline that's on the website too. You don't need to hire a lawyer or a water rate specialist to file a claim. By no means do you do that.